Hi, this is Mitch Peterson. I'm an attorney at the law firm of Davenport, Evans, Hurwitz & Smith in Sioux Falls, South Dakota. I spend much of my practice dealing with land use and zoning issues, which includes participation in the county permitting process. Recently, our legislature adopted SB 157, which makes some changes to how conditional use permitting and other aspects of county permitting and land use processes work. Some of those changes apply to the court process once a county decision is appealed into the court system. But other parts of SB 157 deal with what happens at the county level. Some of these changes are mandatory, while others are optional, where counties need to make a choice whether they want to adopt the changes that are allowed but not required. Under Section 2 of SB 157, it addresses the voting requirement for conditional use permits, and it requires that whatever approving authority is making the decision, it must be a majority of the entire approving authority or the entire board. Before that was allowed, there was allowed some flexibility where 2/3 of the board or majority based on the county's choice could be used. But now it is majority, one size fits all, majority of the entire board. Section 5 of SB 157 is what I'll call the conditional use permit safe harbor, and it simply states that if after a conditional use permit application is submitted, if there are changes to the neighbor's land, like a house goes up or something else is done with structures, that will not affect determining whether the conditional use permit satisfies setbacks or other particular requirements. It also requires that the conditional use permit be acted upon within a year. Section 6 is a fairly significant change, and it applies to Board of Adjustment voting decisions on conditional use permits, and it states that the decision must be based on a majority, not of the entire board, but a majority of the present and voting members, which could result in actually a minority of the board being able to approve something. Sections 7 and 8 deal with the process of appealing lower level decisions to the Board of Adjustment, timeframes, how that's done, and how quickly the board must act. Section 9 deals again with Board of Adjustment vote requirements, and almost everything requires a 2/3 vote of the entire board. So if a zoning administrator decision is appealed, it's 2/3 to reverse. If somebody wants a variance, it's 2/3 in favor of the applicant. The difference, though, is if the Board of Adjustment is acting and making the initial conditional use determination. So sometimes a planning commission might make the decision, and then if someone doesn't like it, it gets appealed, or sometimes it gets automatically appealed up to the Board of Adjustment for a second opinion or an appellate level decision. But in counties that have the Board of Adjustment identified as the initial conditional use determining authority, then it follows the vote requirements of Section 2, which are a majority of the entire board. Likewise, Section 10 largely does the same thing for situations where the Board of County Commissioners are acting as the Board of Adjustment. Instead of having an appointed board, the Board of County Commissioners take off their commissioner hat and put on their Board of Adjustment hat. And that's basically the same thing. It's largely 2/3 of the entire board in order to make a decision, except when the county commission acting as the Board of Adjustment is making the initial conditional use permit decision, in which case it follows Section 2, which is a majority of the board. So there's some inconsistencies. 9 and 10 are consistent in that they require a 2/3 vote on most things, but a majority vote for initial conditional use decisions. The problem is that doesn't square with Section 6, where it says Board of Adjustment conditional use decisions are based on a majority vote, not of the entire board, but of those present. So that may require a court in order to let everybody know how these different pieces fit together, if they do fit together. All of those changes I've talked about are mandatory. There's no choice or local control. Those are things that's what our state government has demanded of our counties. But the SB 157 also provides some options. One of the new classes of permits created is a special permitted use, which is neither a automatically permitted use and it's not a conditional use, it's a special permitted use. And if that is employed by a county, the county must identify all the criteria that must be met in order to issue that special permitted use. And it's issued by a zoning administrator, for example. And if all the boxes are checked, it's mandatory. The permit has to be issued. So there's no public input, there's no hearing, there's no judgment or discretion to be exercised by elected county officials or a board of adjustment that's appointed. It's just automatically has to be granted. So counties that they may like this to streamline things, but the downside is that you lose your decision-making power on a case-by-case basis. You lose your ability to make judgment calls as to what's in the best interest of the county, because sometimes the rules really kind of differ depending on what the particular context is. And it also keeps the public out of the process. So that is simply an option for counties. It is not required in order to comply with the new SB 157. Thanks for listening.